Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Welcome to our Men's Divorce Podcast. The purpose of the podcast is to educate you on interesting family law topics and not provide legal advice. To obtain legal advice, please set up a consultation with us. To do so, call 866-DADS-LAW or visit our website, CordellCordell.com. I am Jerrad, Ahrens, management partner in our Omaha office. Today, we will be discussing relocation and custody matters. An interesting and relatively complex topic. When we talk about relocation and custody matters, what does that mean? What types of issues come up in relocation matters? First, jurisdiction is always important. Where can you file? Discuss the differences between jurisdiction over the children and jurisdiction over the parties. So that's something we want to figure out right away, is who has jurisdiction over the children and the parties. Those could be very different, because then we're talking about home state, which is a legal term which we'll discuss more. Second, what kind of orders are in place right now? Or are there any orders in place? So is there an order for legal custody? Is it joint? Is it sole? Same thing with physical custody. And we're also going to look at what are motivating factors in the move, in the relocation. With me today is Christopher Kennedy, senior lead litigator in Peoria, Arizona. And he's here to discuss this in more detail, the topic of relocation in a custody matter. Christopher, first question, does it matter where you file for relocation?
Yes, actually it does. It matters a lot. So every state in the U.S. is a sovereign state, so it's almost like its own little country. Every state has its own laws and its own rules. So if you file in the wrong place, your case might get thrown out and you have to start all over again somewhere else. So it would matter where you file, and that's going to depend on where you live, where the children are, and where your ex-partner is as well. So I can tell you, typically child support orders stay in the state that made the original order. There's some exceptions to that, but that's where you want to start. If everybody's in the same state to begin with, that's easy. You file in that same state. If the orders were issued in that state, that's fine. If all of you have moved since then, though, you may have to do something like register those orders in the state that you're going to file before you do that. So jurisdiction and where you are and where they are is also important as far as after you file and how you're going to serve those documents on the other party. And then there are some special exceptions for, say, parties that are in the military, active duty, and on deployment. There are special rules that you have to follow as far as service and allowing them to participate, especially if they're somewhere overseas where they can't physically come to court, or they might not have remote access.
Okay. When filing for relocation, are there any restrictions as to timing, distance, or any other kind of restrictions involved?
There are, and again, every state has its own rules. I practice in Arizona primarily, so I can tell you here in Arizona, we have specific statutes that will determine when you can ask for a relocation, how you're supposed to do that, what kind of notice you need to provide. So the statute in our state is 25408. Basically, what that says is if you have an order for joint custody with your ex and you want to relocate, the statute, it's typically if you want to relocate out of state, or here in Arizona, anywhere outside of 100 miles of where the children are currently living. So even in Arizona, if you're going to move a great distance, you're going to have to file notice. So you wouldn't necessarily here in Arizona have to file something with the court. You have to start by notifying your ex of your intent to move with the children.
So that's very different then. So I practice in Nebraska and Iowa. So in Nebraska,
okay,
if you're seeking relocation from a different state, you've got to file that, get the other party served. You could be moving across state lines, which is 30 minutes away, and have to file it. But you could move 6 hours away, but still in the same state and not have to file it. It's probably a different action. It's probably a modification of some kind, but not a relocation case. That also practice in Iowa, where if it's 180 miles or more, then you've got to file for that relocation. So every state's probably a little different. I think there's probably some similar factors in every state that are considered, but the procedurally and statute-wise, probably a little differently. Does it matter what my prospective client, what their current parenting time and or decision making could be when considering a relocation?
It does. You want to figure out where you are in your case. I mean, if you're in the middle of a divorce, that's going to be different than if you say have been divorced for a year or divorced for a few years. So if you're in the midst of a divorce proceeding, you may not be able to just up and move with the children, and you would most definitely have to have permission from the court to do that by filing some kind of a temporary order. Conversely, if you don't have any custody orders, either you've never been married, you've never established custody, or just aren't any orders, then yeah, you'd have to establish those custody orders first in most circumstances. Otherwise, you could, be subject to, the kid grab you and pull you back with the kids.
Yeah. So I was just going to ask you, if let's say there are no orders in place and you just take off and you relocate. What's the ramifications of that?
Well, I mean, if there aren't any orders and the court doesn't have a case with your kids, then they're not really going to know necessarily. But, we all know in real life, if you do something like that, your ex is probably going to tell someone, starting with the police. And shortly, you probably will be dragged into court. So some of those ramifications, I mean, obviously, you could be ordered to return with the children to the state, and that can mess you up if you've already rented or purchased a house or started a new job, have the kids in school. That all depends on how long it is, too. I mean, in some circumstances, if you move and you've been there for a certain period of time, now you've reestablished the home state, which you mentioned earlier, for the children in some other location. In a case like that, your spouse is going to or your ex is going to have to go to where you are and initiate. But some of the other consequences, I mean, obviously having to return with the children is the most important one. You might have to pay attorney fees for unreasonableness. You might have to, uproot the children or change your custody agreement. All kinds of.
Going back to home state, so I'm a little rusty on it, but home state, that's usually the state that has jurisdiction over custody, and where the child has been a resident, or children has been a resident for 6 consecutive months or more. Is that correct?
Yes. Yeah. And most states have adopted what's called the Uniform Child Custody Jurisdiction and Enforcement Act. It's a mouthful. We call it the UCCJEA. So most states have adopted that, and the terms, according to the UCCJEA, is that, yes, wherever the children have been physically present for the 6 months prior to any action being filed with the court, that is determined to be their home state.
Right, and then if there isn't a home state, there isn't that 6 consecutive months or more, then we're talking about what contacts with the state, or what state makes the most sense. Does that sound right?
Yeah, that gets a little messier, because then, yes, you have to go in and kind of prove which is going to be the most likely to be the home state. Yeah, where the kids have, maybe where they're enrolled in school, where their family is, how long they've been there. If they've jumped around, they've never stayed anywhere for 6 months, which state, yes, like you said, has the most contacts. Which court would be able to most conveniently call witnesses and have everyone appear in the same place. So there's a lot of factors that the court would have to determine at that point, to see what the home state is.
Speaking of factors, this is kind of the meat and potatoes of the case. What factors will the court consider in a relocation case?
So there's similar factors that you'd have in a custody case, and not everyone's familiar with custody cases, but in general, the court starts with what's called the best interest of the child. It's important to know with a relocation that the most important factors that the judge has to consider is what's best for the child, not necessarily what's best for the parents. So you might have this great job, or you might, have just married a millionaire and you're going to be set for life, but they want to move to, say, South Dakota or Alaska. That's great for you, but unless you can really show that that's what's best for your child, you're going to have a hard time getting a relocation. So,
yeah, best interest of the child seems easy, seems pretty straightforward, right? And sometimes it is.
yeah, it's not. It's not.
But sometimes it's very complicated.
It can be, and every state's going to have an outline of or a statute that's going to give you some of those factors. I can tell you here in Arizona, the first factor is going to be like the party that wants to move. So you want to move with your kids. What's your ability to have primary custody of those children? Are you even eligible for that? Has there been domestic violence between you and your ex? That would be important. Is there drug or alcohol abuse? That would be important too. You have some felony convictions. That might not make you particularly the best parent to have primary custody. So that's the first thing the courts are going to look like. Are you as a parent able logistically and legally to have primary custody of the children? If that's a no, then you're dead in the water. If that's a gray area or a yes, then then the court will move on. At that point, once you've determined that you are willing, able, and eligible to be a primary parent, the court's going to look again now, is that best for the child? And some of those factors are, number one, is this request in good faith? Is it have for a good reason? Or is it just out of spite or just to interfere? Some people might want to move just to get away from their ex and subsequently take their children, and that's not a good reason. The courts, if that's revealed in court, the judge is probably not going to let you move with the kids.
Then we're talking about alienation potentially, right?
Correct. Yeah, that could affect your overall custody as well. Again, you're going to have to really show what advantages it is for the child. Some of those things, there's no hard list of what you got to prove, but some of those things to show that would be beneficial for the child would be just to start better schools. You got great educational opportunities for your children. If you have really strong familial relationships, aunts, uncles, cousins, grandparents, you got a good support system in the state. That's going to help way towards, that would be good. It's always good for children to have a good support system. What other advantages, let's say you're living in an apartment here, you have the opportunity to, buy a nice house with a bit of land. They'll have fresh air, that kind of stuff. I mean, these are all sort of not really concrete factors, but every little bit will add up. You want to just kind of throw every advantage for that child that you can conceive or perceive, and try and convince the judge that it will be better for your children to move rather than to stay where they are. Let's see, another factor would be, if you do move with the children, how willing are you going to be to let the other parent have their parenting time? So if there's a lot of animosity between the two of you and there's a history there of one or the other of you withholding the child or restricting their parenting time, and then that parent wants to move and take the kids even further away, the court's really going to look at that as far as how likely, if you've had problems, you guys live practically next door to each other, and you're having problems now, you're keeping the kid from her or vice versa, what's going to happen when you're 200 miles away? That's going to be even easier for you to say, nope, no, so that's a factor. How the move's going to affect the child emotionally, physically. If you have children that are in therapy or you have particular needs or issues, what are the availability in the new place to address those needs? Is this child going to be, severely traumatized by a move? All of that you want to try and consider, or the judge will. And then, how stable is this move? Is this a temporary move? Is it, we found a forever house and I'm going to be at this job forever or for a long period of time? So the judge is going to look at that too. What's the likelihood of a stable environment for the child?
Yeah, in my experience, when it comes to the best interest of the child or children, stability is always huge, right? It's
Yeah.
a primary factor. Stability is typically seen as, absent some kind of crazy, unstable environment. Stability is huge. They want to be around their friends, their family, same school. It's usually where they thrive, as opposed to pulling them out of that situation into something foreign to them. Kids are resilient more and more these days, but yet taking them out of their situation usually isn't a good thing. I'd also add, in Nebraska, for whatever this is worth, in relocation cases, primarily what's going to get you an order allowing a relocation is a job, is a significant job in a different state that you couldn't get in Nebraska or the state you're living in.
Yeah.
So that's always a big one. I mean, outside of that, it's going to be really tough to get that relocation granted. And as you know, relocation cases are usually pretty litigious. It's pretty rare
Yes.
that they settle. Like, people aren't just going to agree that you can move it to a different state or are far away with my child. So,
Right.
so you can do mediation, you can do settlement conferences. In my experience, relocation cases are very, very rarely ever settle. So it's like, just get the court date. Like, let's get this to trial as soon as possible, because maybe we've got a school year starting. So we got to get them enrolled in school. But like, we know we're not going to agree on this. So the sooner we can get this resolved one way or another, the better. So, what if I don't live in the state where the original orders were made?
Well, we addressed that a little bit earlier, but yeah, you might have to register those orders in that state. If you are the one wishing to relocate and you're in the state and the children are in the state and those original orders were not in that state, you're probably going to have to register them before you can request that move. If mother and the children are still, or your ex and the children are still in the original state, and you live somewhere else and say want to bring the children there, well, then you wouldn't necessarily have to register them. But yeah, you'd have to figure out where the original orders are, where all the parties are, to determine whether or not you have to register those orders before you could make any changes.
Absolutely. Last but not least, what other things should I or a prospective client consider when assessing a relocation case?
You want to know first and foremost that any relocation case is an uphill battle. So you really want to consult with an attorney. You want to know what the rules are. You want to know what the laws are. You want to know what your chances are. And just know that you are, like you had said, Jerrad, there's not a lot of settlement in a relocation case, so you're going to be up for a fight. And if you are the one wishing to relocate, that is, the burden of proof is on you to show that that's going to be best for the kids. So that could be high. So I would consider that. Timing is everything. These cases are not resolved quickly, at least not here in Arizona. It could be 6-8 months, a year. So if you're filing a relocation in June and you expect that you're going to be able to get the kids for August to start school, I'm sorry, buddy, but no, you probably will not. And you maybe before Christmas, but so plan for that too. Consider, can you even enroll the kids halfway through the school year in the new school or not? And maybe you want to wait. So you want to think about timing. You want to consider too that anytime you are trying to modify parenting time or a parent's parental rights, the courts take that very seriously. So a modification is not any kind of termination of parental rights. That's an entirely different legal situation. And again, you got to show that the move is for the best for the child, not necessarily for you. And I'd say for most importantly, if you're thinking about it, you should definitely consult with an attorney, whether you hire one or not. You should at least talk to one, because there's a lot of little moving pieces. You can get yourself into trouble very quickly if you don't know what those are or how to plan for it.
Yeah, absolutely. You want to consult or retain an attorney that is going to tell you the truth.
Yes.
Not an attorney, especially in these situations. You don't want to consult or retain an attorney that's just going to tell you what you want to hear. Because like you said, these are an uphill battle. I'd say more often than not, it's not in the best interest for for the children to be relocated. So every case is different. The facts are always different, but you want to get an attorney or consult with an attorney, retain an attorney, hopefully a Cordell attorney. If not, someone that's going to tell you realistically what this case is about, what it's going to look like, what are the odds of success. No one should ever guarantee anything when it comes to these cases, but it's an uphill battle. And so, again, you don't want to be talking to an attorney that's just going to tell you what you want to hear. So then you retain that attorney, you feel good about it, and then, thousands of dollars later, year down the road, you've lost. So always important to be particular with the attorneys you discussed your case with. So on that note, that's it for today. But a reminder to consult with us, Cordell and Cordell. Please contact 866-DADS-LAW or visit our website, CordellCordell.com. Thank you.